Hello.
One. Yes,
Hello.
ma'am.
Am I audible?
Yes, ma'am. Yes, ma'am. Yes, ma'am. It's fine. It's fine. Yes. So we are starting. Good evening, friends, and happy Teachers' Day to all. And on a Teachers' Day, we thought that the best way to move the session forward was to call a professor. As you would have seen that we have been calling uh, advocates, judges, senior advocates, and other professionals, though there have been occasions where professors and associate professors have been there. So on a Teacher's Day, we thought that the best thing forward is that we should call a teacher who can show us the light on a day of a Teacher's Day. And I know that Dr. Topi Basar, the associate professor in National Law University and Judicial Academy, Assam, was quite engrossed with her day-to-day course plus how to move forward for the teaching. But we requested her and she was kind enough to accede to our request. And we are also thankful to Professor B.T. Kaul, who was the link between us to connect her. And it's one of the rare occasions that we have been connecting our resource person from the East, or we can say the Northeast. And in this way, I can say that what we have written in our invite, that she is the first of doing LLM plus PhD from Arunachal Singh. So we can also say there's another first, which ma'am can always add on Beyond Law. It's the first resource person coming from the Northeast. So we are glad. But she has also her roots from, since she was an assistant professor in Faculty of Law, University of Delhi. So that connection and that route helped us to connect with her. And she's an expert in constitutional law, intellectual properties law, international trade law. And she has also participated in various national and international seminars and workshops, and has done a lot of research papers which have been published in reputed research journals. And she has been observer in several selection committees for lecturers at Delhi University and is an expert of several interviews. So the wide spectrum of knowledge of ma'am is a testimony of the fact that, as we say, that we all on the platform of Beyond Law CLC try to bring the best speakers around, not only in India, but from abroad also, which those participants who are watching us live on the Facebook as well as on this platform know it very well, that we have also called speakers who have come from abroad. And welcome, ma'am. And as we start the session, happy Teachers' Day. And that gives right impetus to move forward in this webinar.
Thank you so much. I'm very grateful to be on Law CLC for giving me this opportunity to have a conversation with all of you and with the world at large on a subject which is very dear to me. And I am very grateful to Professor B.T. Kaul, my Guruji, who guided me in my PhD in this area and made me what I am today. And thanks to him. And happy Teachers' Day to all of you, because I know that all of us, even if we are not professionally teacher, but we all are teacher in some capacity, in some way in our lives. So happy Teachers' Day to all of you. And this is a very good occasion for me to share my views and my opinions on a domain, on a subject matter which is very important, about which very little awareness and understanding is there amongst the intellectuals and amongst the educated people also. Today I would like to talk about traditional knowledge and the issues pertaining to traditional knowledge, and how the regime of intellectual property right, how it views traditional knowledge, and what kind of legal a legal locus standi, traditional knowledge, has in the paraphernalia of intellectual property law. Whenever I go to any forum or whenever I go to any place where I have to speak about traditional knowledge, the first thing that I encounter is people, they really don't know about this concept of traditional knowledge. The first thing that they would ask is, what is traditional knowledge? Although all of us, uh, uh, actually, all of us are steeped deep in traditional knowledge in our daily lives. But when it comes to articulation, perhaps people are not able to understand it, and people are not able to really people are really not able to identify uh, the legal status or the position of traditional knowledge. Recognition, basically recognition of traditional knowledge, and awareness level of traditional knowledge is it's very minimal. So, uh, like my association with this topic of traditional knowledge goes back to my PhD days when, after my master in law, I took up this area to pursue my PhD from University of Delhi at Faculty of Law, where my professor B.T. Kaul sir guided me in this area. So when I pick up this topic, the area was also very new to me. Uh, it is while researching that I learned the true value and significance of this area of law, traditional knowledge. I'm not going to give you any definition, about what is the legal definition of traditional knowledge. How does law define? Because as a legal person, we are always looking for what is the legal definition of this subject matter. Okay, but regarding traditional knowledge, uh, I'm sorry to say that there is no definite definition. There is no legal definition of traditional knowledge. Why? Because still we do not have a law in India dealing with traditional knowledge in a complete sense. Although the traditional knowledge has been referred in some areas of IPR, intellectual property laws, but this term is not being defined uh, because of the absence of sui generis law protecting traditional knowledge. So everybody around the world understands traditional knowledge in their own way, you know. Uh, Being an indigenous person coming from Northeast, and born and brought up in an indigenous society, uh, steeped in traditional knowledge. So, for us, traditional knowledge is a knowledge which originates from our community, where we learn from childhood itself. We learn how to live, and how to depend, and how to draw sustenance, and how to draw from nature, and how to fend ourselves from nature. So our orientation about traditional knowledge in an indigenous community begins at a very young age, because I remember when I was a small girl, I used to go with my friends and with my relatives to the wild to collect wild vegetables. for our food, wild vegetables. So we were told by the elders where to find the location of that uh, wild vegetable, from where to find, and we were told what all special in qualities and characteristics those vegetables contained, and what all medicinal properties those wild vegetables contain. So, from the very young age, this kind of doctrination, this kind of training was imparted to us as to how to understand the nature, how to understand the ecology, and how to identify the food that is offered by the wild, and what are eatables and what are poisonous. So we were told, we were taken to the wild, and we were trained to identify what are eatables and what are not eatables. So this is all part of traditional knowledge of indigenous community. Traditional knowledge may be associated with a plant. Traditional knowledge may be associated with agriculture. Traditional knowledge may be associated with environment as a whole. Traditional knowledge may be associated with animal husbandry, your food preservations. It's so broad. The gamut of traditional knowledge is so broad that it includes culture also, it includes tradition also. So uh, uh, traditional knowledge as a concept is so broad that it includes many subsets within itself. It includes many sub segments within itself. For example, cultural expressions, folklores, folk songs, music, traditional music, traditional architecture, traditional pottery making, any kind of traditional artifacts where traditional artistic works are involved, and traditional products result from the artistic workmanship. So all these are part and parcel of traditional knowledge, where traditional know-how is involved. Know-how is involved, and this knowledge is not owned by individually. It is handed down from generation to generation. So, in Indian context, whenever we talk about traditional knowledge, it is it is associated always with turmeric patent, neem patent, haldi patent, and basmati patent. So the moment I say to people that I deal with subject matter that involves study of, turmeric patent, neem patent, and basmati patent, done by USA, which India had to get it revoked by waging a legal battle. So then people relate, okay, yes, okay. Then that's how, So, but the concept of traditional knowledge, the scope of traditional knowledge is much wider. It is not limited to neem patent, it is not limited to turmeric patent, and it is not limited to basmati patent. It is much more. But the question is, how do we legally articulate it? How has it been legally identified and legally validated by the laws of the country? That is the question. Because The importance and significance of traditional knowledge as a legal subject matter grew with the concept of biopiracy. Biopiracy refers to misappropriation of traditional knowledge uh, in a in an unlawful manner, in an unethical manner, by somebody normally from outside the country, because this has happened in the case of turmeric, neem, and basmati. That's how India kind of had to, uh, react, and India had to make a claim of age-old traditional knowledge against this attempted biopiracy, misappropriation of our traditional knowledge, on the contention that how can somebody else misappropriate or get a patent on our knowledge system, which is well known in India for generations, for age old. Every Indian knew about the wound healing properties of turmeric. That's the first thing our grandmothers give us when we fall sick or when we hurt ourselves. The paste of turmeric is topically applied on our wound, or when when we have run high fever, then our grandmothers would add raw turmeric in our milk and make us drink. This is our traditional knowledge of the country. So the dispute was about who owns the knowledge system. The question came to that: who has the ownership over the knowledge? Because this is no ordinary knowledge we're talking about. We are talking about a knowledge which is valuable, a knowledge which has commercial potential. This also brings to another very important dimension of the times that we are living in today. In today's time, in the present generation, knowledge is important. Okay, whoever has the knowledge has the power. Knowledge is power. Money is not power. Knowledge is power. The country which is creating more knowledge in the form of intellectual property right will rule the roost. It's not about, more so about now GDP or about these other economic statistics, economic GDP or national economy. Now we are talking in terms of how which country is generating more intellectual property right, which country is generating more knowledge. Because a country who's rich in knowledge naturally is going to be going to be rich economically and industrially. So commodification of knowledge. Gone are the days when knowledge was shared openly and freely, but now knowledge is not shared openly and freely. And this change has come about in the indigenous community also. Indigenous society like us, indigenous tribal society, we are a very open society when it comes to terms of sharing knowledge. May it be a traditional medicinal knowledge about a plant, it is openly shared because it is believed that it is of some value to mankind, and it has to be shared. And it has been openly, so much so that most of the knowledge is now has gone to public domain. Most of the knowledge has come from the community, indigenous community, to the public domain, either by themselves or through third party. the knowledge system, their rich knowledge system has entered into public domain. Now, the question is, how do you retrieve it back from the public domain and and identify and recognize the true ownership over that knowledge? Because the notion of public domain and the protection of IPR and the notion of public domain and the protection of traditional knowledge, they are all very different issues and looked at and understood with a different perspective, legal perspective. Intellectual property right as such confers exclusive monopoly right. Now, when we talk about traditional knowledge, it is a collective right because knowledge originates and knowledge lies with a given community. Community is the holder of that particular traditional knowledge. So it is traditionally owned collectively. The ownership is collective. Now, how do we juxtapose this collective ownership of knowledge system within the framework of IPR, which is quite contradictory, which is quite contradictory. Now, how should law respond to this? How should policies respond to this? Because today we are talking about self-reliance, Atmanirbhar, then, and we are talking about indigenous production. Okay, we are talking about creating everything by oneself within us. Now, in a time where we are emphasizing about self-dependence in economic terms, then the importance of traditional knowledge has become all the more prominent. So a time has come where we need to give a legal recognition to traditional knowledge and help the communities who are rich in traditional knowledge and diverse forms of traditional knowledge to be able to really empower themselves economically, socially, and politically, which IPR may not be able to do. IPR may, to some extent, IPR may be important. And we have under our patent law, which gives a defensive protection to traditional knowledge. Under the Patent Act, traditional knowledge per se cannot be patented. Any invention which is based on traditional knowledge and which is mere replication and duplication of traditional knowledge, an invention which is nothing but mere replication and duplication of traditional knowledge cannot be patented under the Act. Under Section 3P, it is clearly laid down. Okay, it excludes traditional knowledge from patentability under Section 3P of the Patent Act. That's a defensive protection. Excellent, very good. Now, there is also a disclosure requirement under the Patent Act. That means that an inventor, in filing for application for patent on his invention, if he has used traditional knowledge in his invention, for example, an inventor has invented a new medicine, a new drug, and in the research of that drug, he had uh, obtain some lead about that drug from an indigenous community, about the about a plant, medicinal plant, whose knowledge was with that given indigenous community, and the researcher gets the lead from that community about that medicinal property of a plant, and he does genetic research study. He does genetic study of that plant, and research is done, thorough research is done, and then they kind of scientifically validates about the knowledge rendered by the community, and scientifically the plant is proved to be a cure for a certain ailment, for example. Then the inventor, next thing the inventor would want to do is get a patent on it. He files for a patent. Now, under the Patent Act, it states that a disclosure has to be made if any traditional knowledge is used in the invention. So he is legally supposed to make a disclosure, and he makes the disclosure. Okay, he makes the disclosure. Thereafter, what is not mentioned in the law. After making the disclosure, and if the invention qualifies for a patent, he gets the patent. Thereafter, what? Thereafter, what? Is he obligated? Is he under obligation to share some benefits or pay some compensation to the knowledge holder? That part is missing from the law. That part is absent. And that's a very important right that we are talking about. Because today, all over the world, internationally, and under the World Intellectual Property Organization, or UN body, the current the international the members of WIPO are currently looking for negotiating for many years for a legal instrument at the international level, a treaty, a kind of a treaty which will give legal protection to traditional knowledge, which has been going on for decades, but there has been no conclusion to that. It's been going on. So it's not that effort is not there. Effort is there at the international level also through UN bodies like WIPO, where India is an active member, and many South African countries, developing countries, they are proponents of traditional knowledge, protection of traditional knowledge. But in our country, everybody, all the policymakers, people, intellectuals, they all seem to be very supportive about the issues relating to traditional knowledge, but a serious thought from the policymakers has not been given to this issue. But I feel now that the time has come when we are talking about self-reliance, and I think this is the issue of traditional knowledge is very closely linked with the idea of self-reliance, and the idea, or the whole idea of making the community self-dependent on the resources that they have. So this is traditional knowledge is one of the resources which is there with the indigenous community, which really needs to be preserved, which needs to be continued, which needs to be supported and given legal protection, so that this knowledge system does not die down with the older generation. It is continued, it is sustained. Let me give you an example. We have a law, like we have many IPR laws which can be used in some way, which will support these knowledge systems in promoting and preserving and even marketing it in a proper way. Geographical Indication Act is one of that law, which is also an IPR, Geographical Indication Act. There are innumerable traditional knowledge-based products, which will be, which are extremely, extremely unique, and which can be a big thing in the market commercially, if marketed properly, if manufactured properly. So this traditionally rich products can be obtained. GI registration can be obtained on these products, and these can be marketed well. I mean, there can be strategies. We can develop strategies whereby these traditionally based products, the products which is made traditionally, and which has some which contains traditional knowledge, because traditional knowledge may be contained in the way the product is being made, the how it is manufactured, how it is processed, and there are a whole lot of culture involved in it. For example, the indigenous communities and tribes are very rich in handloom. They are very rich. They have very rich tradition of handloom, handloom. So some of the handloom woven uses traditional techniques, traditional methods of weaving. They are not using machine. They use traditional methods. Now, these products, unique products, can be registered under the GI Act and can be commercially launched. In this way, we will be protecting the knowledge component also, and also we will be helping them in economic upliftment. So this is one dimension of traditional knowledge. And second is, like, when we talk about now we are talking about, we are also concerned with the fact that rich traditional knowledge in different fields are also slowly disappearing. They are dying down because the younger generations are not taking it up, because there is no awareness about it to the youths, to the children. This is also a big concern. So agriculture, people are giving up agriculture. So when you give up agriculture, your traditional knowledge, some of the traditional knowledge associated with agriculture also goes away. So this is a big concern. So there is a dire need today. There is a dire need today to identify important knowledge systems in different pockets of the community, in different regions of India, and to preserve it, and to encourage the youths to take it up, and to make a thorough scientific study of the knowledge systems involved, and to preserve it, and to document it. So documentation is one important aspect of traditional knowledge, because this rich and valuable knowledge systems are also fading away because of the lack of interest in the younger generation, newer generation, in learning these knowledge systems, adopting these knowledge systems. So there is a need to document these traditional knowledge systems. So for this, our Biological Diversity Act, although it is in relation to biological resources, including plants and animals. So it covers biological resources, which includes plants and animals, but also it includes associated traditional knowledge about these bioresources. Okay, so it also covers traditional knowledge associated with bioresources. Now, Biological Diversity Act 2002 is a very important piece of legislation which has a provision under it, and it mandates the biodiversity management committees at the local level to prepare people's biodiversity register. Now the question is, in how many states these BMCs are functioning in a vibrant way? They are there, they are being created, but how many BMCs are are being very proactive? Because one of the main function, BMC is Biodiversity Management Committees, which is at the local level, at the panchayat level. So one of the main function of BMC is to prepare people's biodiversity register. And preparation of biodiversity register, and this register, uh, in this register, available traditional knowledge associated with bioresources can also be documented, under this register. Now, how many are actually taking it up in a serious way? Barring state of Kerala and a few other southern states, I don't think this mechanism, BMC mechanism, and PBR, People's Biodiversity Register, is being taken up uh, seriously at a policy level or at an administrative level. But let me make it very clear, at the community level, okay, as a customary practice at the community level, many many activities like this are there already at, at the community level, which is outside the legal structure. I am saying customarily, under the customary law, maybe under their self-created protocols, community protocols. So many activities are there which can be legally supported, and which can be administratively supported, and this can be linked up. This can be linked up with the work of BMCs, Biodiversity Management Committees. So this will create job opportunity for the youth, unemployed youth in the villages also. And the brighter side of the thing would be, it will be protecting the environment, ecological balance will be maintained, and we will have the repositories, documented repositories of we will know what all traditional knowledge are still in existence with the community once the thing is in the register, and and the recognition of that community, and and the title of that knowledge system, the title should be with the community. So there is a need for legal clarity on this, because when a knowledge is recorded in a register or in a database, a knowledge is recorded, it's important to determine the title, ownership of that knowledge system, because the objective is to that the knowledge is shared with all, everybody gets benefit of the knowledge, but at the same time there has to be compensation, economic benefit to the community as an incentive, so that that knowledge system is continued, or that knowledge system is sustained and preserved. So these are all matters of policy, and all these are made. It's not possible to write it down in black and white all the time in the statute book. Many things have to come from the policies which is made at the local level, administrative level, and with the participation of NGO. So what I am trying to argue here is that traditional knowledge, which is a gamut of knowledge systems, which covers diverse forms of knowledge, may it be culture, folk song, folk dances, may it be medicinal knowledge, knowledge of food, ecology, so on and so forth. So the real essence of traditional knowledge has not been captured by the law in India, and there is a need to do that, especially in copyright. For example, copyright has no space given for cultural expressions like folk songs, folklores belonging to a community. There is no space in copyright. Copyright is only protecting author and the owners of that creative work, literary work, and artistic work. Okay, so copyright will only protect individual monopoly rights. Where is the space for cultural expressions of a community? For example, a traditional folk song of a community, if it has to be used in a cinematograph, traditional folk songs is to be used in a cinematograph. The maker of this film has to obtain prior informed consent from whom? Is it mentioned in the copyright law? It is not. And in the event of such misappropriation of a cultural knowledge or a cultural of a folk song in a cinematograph, what is the remedy available? Issue is not about stopping the use of knowledge by others. Larger issue is equitable sharing of benefits, so that this knowledge system is preserved, this knowledge system is sustained, and the society, the holders of that knowledge system is able to get some benefit as an incentive for keeping that system alive for generations and generations. So cultural commodification is a big question today in the era of intellectual property right. Intellectual property right in the present form does not recognize community intellectual property right, like traditional knowledge and traditional cultural expressions. No, without legal provisions, or without any kind of legal rights and obligations, how these acts of misappropriation, if at all is agitated before the court or judiciary, how is it to be determined? It's going to be extremely difficult for the judiciary also to decide or determine the matter, even though they can see that there is an ethical question involved, moral question involved, because a traditional knowledge is being used without prior informed consent by people who can afford it, by people who are going to eventually use it commercially and reap benefit out of it. But even judiciary will be helpless unless a law is there. So law is not clear about the issues concerning traditional knowledge. There is no legal articulation. There is no express legal rights and obligations. A piecemeal treatment, piecemeal protection here and there under the patent, under the Biological Diversity Act, under the GI is not sufficient. I think if we think traditional knowledge is important for the society, for the country, which it is, and which is well recognized, universally recognized. Now, nobody denies, no country, even US does not deny, which was once upon a time opponent of traditional knowledge. Even US recognizes that yes, there is a traditional knowledge and everything is not public domain. We cannot say that all traditional knowledge are part of public domain. That argument is dispelled with. So then what is the next? And we have been for decades in India also talking and writing, intellectuals are writing about traditional knowledge. But when it comes to legal outcome, it is very disheartening. So I think we have to look within our richness. You know, we are traditionally very rich and culturally very rich community, which has so much potential to offer. We don't even have to look at the West to import something, or we don't have to look at other countries. We have so much within us. We have so much within the communities. Only thing is, we need space. We need clear policies. We need legal clarity because only when there is clear legal policies and the legal clarity, then the funding and the support and budget allocation also comes. So what I feel as somebody who hails from an indigenous community and who thinks that, who believes, I firmly believe that there is so much potential there lying untapped, untouched, which needs proper outlet, which needs proper planning, which needs proper incentives. And I think if that is done with proper kind of an orientation legally, and fine tuning our IPR regime, like copyright, and even coming out with clear legal policies on traditional knowledge. And this can in a way, the policies can in a way address the lacunas, gaps which is there in the IPR, because IPR as such is not designed to protect traditional knowledge. So there is bound to be lacunas. If we look within IPR for the legal solution for traditional knowledge, there is bound to be limitations, because IPR is only designed for protection of some industrial property, for creative works, artistic works, patent, trademark, copyright have different objectives, but objective of traditional knowledge are totally different. So, having said that, I think what we need is a separate legal instrument for traditional knowledge, which will take into account all the legal requirements and and the positive rights and the things which is needed to be done in this area. I think this calls for an urgent attention on the part of the policy makers, because uh, there are so much to find within, and so much to protect, which is getting just, they are going and getting merging with public domain. And who knows, if we don't sit up and do something now, a time will come when uh, whole of our knowledge system is lost and we have nothing with us, and the community will be at a big loss, because that community which has traditional knowledge is not urban, it is not urban center, they live in a different world. And and it's important that we preserve that world also, because the larger interest of the mankind depends on preservation of that world. So that is my submission, and I feel a lot of things can be done legally, socially, and morally. And there are many things being done at the local level, at the community level, which needs to be mapped, which needs to be understood, and which needs to be really given a good push, policy push, and support, and proper incentive is required. And also a new jurisprudence needs to be developed, a new jurisprudence of understanding traditional knowledge, and how to address the issues of traditional knowledge that may arise in the context of IPR. Because in copyright, it's already arising. In design, it's already arising. So many traditional designs are being copied by the designers. So these are already there. So how do we address it, as through IPR, or or judicially? It's going to pose a big problem for the judiciary in future, because these cases have not yet come up, but there is awareness growing. If suppose indigenous design of my community is misappropriated by a designer without prior informed consent, obviously, being some having some knowledge and awareness in this field, I would be the first one to object today. So in that case, what is to guide judiciary? So I think there is a dire need to debate about these matters, to discourse about this, to exchange our ideas and views about this issue. I will stop my presentation here, if that's okay.
Uh, yes, ma'am. Uh, Before we take the questions, in one, uh, if we could explain what are the subtle difference between the intellectual rights, copyrights, and this traditional knowledge, what you feel, and what is the way forward according to you?
See, traditional knowledge has no legal definition, but common understanding of traditional knowledge is that it's a knowledge which is collectively owned by a given community or a society. It can be an indigenous group or it can be a non-indigenous group also. Okay, a knowledge system which is collectively owned. Whereas copyright is conferred on an individual author for an original writing, for an original artistic work. It is his original creation. But traditional knowledge is not somebody's original creation. It is handed down from generation to generation. Can you say who taught us when to eat turmeric and when to apply turmeric as a paste to heal the wound? Different uses of turmeric. It's been there, it's been there. It's part of us. It's been handed down. Our elders have told us about the therapeutic values of turmeric, and that's how I will be telling my children. When you have fever, please put some raw turmeric into your milk and drink it. So this is how we pass on the knowledge from generation to generation. Whereas IPR is not like that. IPR is invented, created by someone, by an individual. So there is lot of point of divergence between IPR and traditional knowledge. The challenges how to legally accommodate the issues of traditional knowledge within the IPR system that we have.
This is a suggestion by Mr. O.A. Srinivas. He says, under the copyright, the same idea is used by different manner or method, but it would be benefit one another's, whereas the traditional knowledge and traditional skill is a community right. No individual can claim any exclusive right. Better it is permanent protection under the GIE Act is available. Further explore the possibilities to develop and protect the traditional knowledge and traditional for the indigenous community for their benefits. What is your take on that?
I agree with him. But what I feel is we are talking about diverse community here. Every community might have their community protocols in dealing with traditional knowledge. And I think we have to have a law which respects that community protocol also. Because ultimately, traditional knowledge is the creation. It originates from the community, right? So the community will also have their own systems of management, systems of regulation. It may be customary or it may be through certain rules that they frame for themselves. Like, for example, they have a rule that whoever outsider coming for accessing our traditional knowledge will require permission from the panchayat. They will require a permission from the village head council. Suppose a rule is in place. This is community protocol. Okay, and that community protocol will have to be respected by the law. Okay, so there has to be a coordination. There has to be a policy must be synced in such a way that they are not going in opposite directions, rather they are going in one common direction, because the goal will be same, objective will be same. Because we are talking about a possibility of, like, in future having a law protecting traditional knowledge. If we are talking about that, if our policymakers are serious about it, so this is how, we have to take into account community protocols, customary practices also in the larger legal policy framework.
Okay. And let's assume there is a breach of traditional knowledge. Who can invoke the jurisdiction and how?
That is my question. That is what my entire presentation is hinging on. There is no lack of clarity.
It says, yes. No,
yeah.
What could be your take? How to put things forward?
See, what I'm saying is there has to be a clear-cut policy on this, law on this, protecting traditional knowledge. Okay, like for example, we have a GI law now. Okay, and GI matter goes to registration of GI, etc., etc., and disputes in relation to registration goes to IPAB, Intellectual Property Appellate Board. It goes there, and from there it can and the infringement can be filed in the district court, and matter can go to high court. This thing is there. Jurisdiction is clear. But when it comes to traditional knowledge, since there is no law, so when a breach occurs also, where do we go? Which forum do we go? Okay, okay. One can say an NGO can file a writ petition. Okay, is on the ground that it involves violation of fundamental rights because it is connected with livelihood and fundamental rights of the community. So one can file a writ petition, but that's a very rigorous thing. No, that's a very rigorous process. It's not easy for a common man to a simple community people to even know about what is writ jurisdiction. And for an NGO or for a lawyer to do pro bono on it, how many times they will do pro bono? Not always. Maybe at once in a while, once in 100 you'll do pro bono to advocate on a matter like that. But we don't have a lawyer. I don't come across any social activist lawyer who has taken up the issues of traditional knowledge so far. It has become only a domain of researcher and academics till now. I have not seen any lawyer who's interested in these TK matter. And I'll be very happy, to, as an academician, to work if any lawyer comes up and says that, okay, I will want to advocate in this area. I've not come across any. Somebody has written GI Act is enacted only to protect traditional knowledge and traditional skill. Okay, Mr. Srinivasan, thank you for that question. But I agree with you. Yes, GI gives indirect protection, but GI is a tool, marketing tool. GI is a indication, geographical indication. It's an indication that the given product is originated from a particular geographical territory. Like for example, in Assam, in our Assam context, Assam Muga silk. Muga silk. This is a very special kind of a silk which is traditionally made in Assam only. So this Muga silk has been registered under the GI Act. So once a GI tag is given, means you kind of enjoy certain status in the market. That product is well known because you have a GI tag, because of your uniqueness and because of your reputation. Because of the reputation of the product, GI tag is given, and that reputation comes from a given geographical territory. So GI is mainly a marketing tool. It has to be looked at as a marketing tool. Of course, I agree with you. In an indirect way, it has the potential to protect traditional knowledge which goes along in making Muga silk, because there are traditional knowledge involved in making Muga silk also, especially in the rearing of the silk, that particular silkworm, which is reared in a traditional way, and it is possible only in this region, nowhere else. So there are traditional techniques also involved in this. Okay, but the main objective of GI is to give recognition to those unique products, reputed products coming from a particular geographical territory. That is, so traditional knowledge requires a separate treatment altogether, holistic treatment altogether, a comprehensive treatment altogether, because traditional knowledge is an umbrella term. It includes within itself different segments. That's the point I'm making.
The last question we will take. Uh, Armstrong says, ma'am, what is the comparison between the intellectual property and GI?
GI is a part of intellectual property. Intellectual property is a common nomenclature given to copyright, trademark, patent, GI, Design Act, Semiconductor Act. So it's a common nomenclature, but it is the IPR includes within itself copyright, patent, trademark, all these GI, etc.
Ma'am, the session as we started at the first instance, it's like what you said, I can say it's more like a area which is not explored much, what we have gathered during all your session. And there are
let me make one thing clear. It is for a purely legal person, a lawyer, a criminal lawyer, for example, will be very difficult to understand and even think of practicing in this side of the law, in this kind of creating a niche in this. But I'm telling you, I think if you are able to make a niche in this area, okay, you will be doing a great community service, and it will be a great community lawyering, which in many other countries like Latin American, South African countries, many lawyers take up these kind of laws affecting communities. So community lawyering is very fashionable in Latin American, South African, and Aboriginal countries. But in India, community lawyering is, I am sorry, everyone runs up the criminal cases, constitutional cases, but very few who's doing community lawyering. I think this needs to be focused more.
Since there are young participants also on the Facebook and with on the platform also, though the topic looks very simplistic, could you just explain the concept of community lawyering to the participants?
Community lawyering is, you going to the community and trying to understand and identify the problems that that community is facing. It may be in anthropological problems, it may be sociological problems, it may be ecological problems, it may be vulnerabilities due to environment change, So go to the community. You will know the problems only when you go to the communities. Our young lawyers are not visiting the community. You have to go there and try to understand the problems that they are facing and bring them up before the judicial forum and the appropriate forum. This is what needs to be done in India. It's not only about, that the top lawyers are only the criminal lawyers. How many lawyers are there who are community lawyers, who are advocating for the rights of the community, natural resource-based lawyers? Very few of them. You need to change your orientation. We need to really look inward, look untrodden paths, and a lot of potential is there.
So thank you, ma'am. Before we part, the seeds which you have sown in the minds of the participants, not only on the Facebook as well as on this platform, I'm quite sacrosanct to the effect that even if 5-10% people take the things forward, what you have taught for, and at least certain new issues like GI, community lawyering, traditional law, these are, I would say, more or less akin to a virgin areas where they have not been covered as such. And once you get some light, then you actually get the path to be developed. And on a teacher's day, as they say, that where there are dark alleys, the teachers act like a lamppost to show the light of that path. I can only dedicate this thing that once you have shown us an area which a lot of people can think of creating a niche in this field. And once you get a seedling grown in the mind, you can actually develop it into a plant which actually can be a better way for the society and the community to move forward. The last is one Aishwarya says, how to initiate community advocacy.
Community advocacy you can initiate by, of course, before understanding the problems of a given community, you should know about that community. do some research and study on that community, whichever community interests you. We have plenty of community which needs that kind of help and assistance in different areas for them to socially articulate. So first of all, identify the community, try to know them, do some research, and try to understand what are their potentials, what are their weaknesses, what are the problems that they are actually facing, which they are not able to take it up before the appropriate forums. So that's how, and get in touch with NGOs working. NGOs are working, but many of them are non-law people. Okay, legal people are not part of these NGOs, community-based NGOs. So I know one community, very vibrant community in Arunachal, JRK. Okay, it's a very socially vibrant community in Arunachal Pradesh of Galo tribes. It's JRK. So they have a website also. Reach out to these communities and try and understand what are the problems and issues that they are facing with. And you can be a bridge, or you can be a bridge between the community and the system as a lawyer, because you have the legal knowledge and you have the capacity to articulate their problems before the right forums in a right way. So that kind of intervention pro bono is the need of the hour.
Thank you, ma'am, for all the insights having been given to a topic. As I said, it's more akin to virgin areas, and you have just planted the right seeds. I'm quite hopeful that someone somewhere down the line will start taking it up, and it will be a big way. Where you have created a hope, I'm quite hopeful that that hope will ultimately create into a right shape and the right form, and you would feel happy that the seedlings sown by you in the mindsets have actually taken right shape in the right direction in coming time. Thank you, everyone. Stay safe, stay blessed, and happy Teachers' Day once again. Just remember the teachers who have shown you the right path to move in the light. Right. Stay safe, stay safe.
Thank you.
Thank you. Namaskar.
Thank you.
And before we part, tomorrow, I just forgot, tomorrow the session is Adoption and Surrogacy, Comparative Analysis with Legal Perspective. And the topic would be by Justice C.S. Dias, a sitting judge of Kerala High Court. Do stay connected with us tomorrow at 5 p.m. Thank you, everyone, once again. Thank you, ma'am.